Good afternoon, everyone. My name is Michael Aylward, and it's my pleasure to welcome you to the fifth of a series of webinars that the American College of Coverage Counsel has been presenting over the course of this pandemic, discovering the insurance implications of COVID-19. The ACC is a group that was founded 9 years ago to advance the goals of professionalism, scholarship, and collegiality in the fields of insurance and bad faith. Our members truly comprise the go-to lawyers that American and Canadian businesses depend on for insurance advice, whether those clients are policyholders or insurance companies. Today's program is being presented in partnership with the University of Pennsylvania Law School. One of our core missions, as I mentioned, is scholarship. And we've been looking for areas where we could partner with the law schools that are educating the next generation of insurance coverage lawyers. UPenn, largely through the efforts of Professor Tom Baker, who's on our faculty this afternoon, has really been at the forefront of insurance scholarship since Tom went to Philadelphia in 2008. More recently, Penn's COVID coverage litigation tracker has been an indispensable tool for those of us who are down in the trenches in the COVID litigation. As I mentioned, this is the fifth program that the college has presented on COVID. Unlike the first four programs, which were largely surveys of the emerging trends in case law, this one is going to be very specific to two industries, sports and entertainment. Neither of those industries was a major player early on in the litigation when we were dealing with restaurants and hair salons and things like that. But as you'll see, sports and entertainment industry policyholders are really at the forefront of some of the largest and most complicated cases, and I think are going to be a very important area. And yet, of the 350 opinions that have been handed down so far, none deal really with sports or entertainment or the specific issues that you'll be hearing about. So there's a lot of uncertainty that we hope to shed some light on in the program this afternoon. Given the size of our audience, it's not practical to let you all go live. What we would ask is that you save your questions for the end. And in the interim, I'll be moderating this. If you'll send a question via chat, we can ask our speakers. With that, let's get started. My job is to set the table for what's to come. And what I'd like to do in the next couple minutes is sketch the course of what truly has been a litigation pandemic to go along with the disease itself. It's hard to believe, but this all began just over a year ago. The first DJ was filed in New Orleans on March 16. Today, there are over 2,000 individual cases, a quarter of which are class actions, although none have been certified. And these nearly all involve business interruption claims. So far, nothing on one case on CGL, nothing on D&O, nothing on E&O. That's the scale of the litigation as it's developed. I mean, it's been a steady climb in terms of the number of lawsuits. And there's litigation just about everywhere except places like Alaska or Wyoming. But where it's really concentrated are the major industrial states with large service industries like California, Florida, and Pennsylvania. Right now, Pennsylvania leads the way, closely followed by California and Florida. What has been the evolution of this litigation? I mean, how have we gotten so far in only 14 months? The early litigation was pretty straightforward. As I mentioned, it was pretty much restaurants and beauty parlors. And the lawyers that were filing those cases were not people that most of us had heard of. You could speculate about why that was. Some of the bigger law firms waited to get involved. I think to a large extent, nail salons simply didn't have connections with large, sophisticated insurance law firms, or the law firms wouldn't take these on contingencies. In any event, about 2 months after the litigation started, we suddenly started seeing national class action firms getting involved. Not necessarily firms with a lot of insurance experience, but plenty of experience in filing suits against financial institutions like banks for consumer mischief. The effort was immediately undertaken by those firms to get MDL recognition, to get all these cases consolidated, which would have been very unusual for the MDL statute, but nonetheless, 3 proposals were floated for Miami, Philadelphia, and Chicago. Those proposals were finally rejected in mid-August after an enormous amount of briefing and an unusual situation where you had both insurers and a lot of policyholders lining up against the proposal. And the finding was that these cases were just too diverse. There were too many decision makers, too many different policy wordings for it to be at all efficient. The JPMDL did allow mini MDLs against Society and Erie on the grounds that there were efficiencies to be gained because those were regional carriers with uniform policy wordings. So phase 3 started during the summer while the MDL was still pending, when insurers looking at dozens and dozens of new cases every week said there was really a need to stop this, that the carriers would be more aggressive than might ordinarily have been the case with early 12b6 motions. It was difficult for a while to get rulings while the MDL petitions were pending because the federal district courts didn't want to exercise jurisdiction over cases that would be taken away. But once the ruling was issued on August 12, the floodgates opened, and there has been a flood of cases, flood of rulings ever since Labor Day. I'm not sure if you could see it very well, but the bright line in the bottom are the pro policyholder rulings. The light line stretching up towards the sky are the rulings for carriers. It was very slow until about October, and it has simply taken off ever since. As of this morning, according to the COVID coverage litigation tracker, which I check every morning, thank you, Tom Baker, there have been over 300 opinions. And the number of cases that insurance companies have prevailed in is frankly staggering, even for somebody who represents insurance companies. To date, we've prevailed in 85% of these cases. And when I say prevailed, we've obtained either summary judgment or a motion to dismiss. If we've lost, it's mainly been on the basis that there are disputed questions or a motion to dismiss was just inappropriate at this point. Policyholders have only actually prevailed or obtained a judgment in 2% of these cases so far, 7 cases. What you can see, though, is that there's a real difference in the outcomes between state and federal courts. I know Tom will be talking about that a little bit later. The principal issues are pretty well known to anyone in this area. Most of the decisions have all been about direct physical loss or damage, or to a lesser extent, virus exclusions. And carriers are doing pretty well on direct physical loss. But there are a small but possibly influential number of rulings that focus on whether there's a possibility of the virus being physically present on the property, or some courts that have distinguished between loss and damage and found that the loss of use is loss. Carriers are doing very well on the virus exclusion, and so far issues like is a virus a pandemic or regulatory estoppel have not gotten any kind of traction. But there are issues with other exclusions like microorganisms, and whether a dead thing like a virus is a microorganism. The current phase that we're in, we've been through the little fish and the sharks. Now we're into the big fish. And this is really what we'll be talking about this afternoon. We're not dealing with Gene's Nail Salon anymore. We're dealing with CVS Viacom or Major League Baseball, or hotel chains or casinos, very large, sophisticated, lawyered up entities. In fact, a lot of the little fish have disappeared. I've had 6 DJs get voluntarily dismissed in response to 12b6 motions on the theory that they were likely to lose and they'd rather wait and refile if the case law improves. The 5th phase, even while the 4th phase is still going on, are the appeals. There are 350 decisions. About a third of those are now up on appeal, principally in the federal courts, principally in the 4th and 9th Circuit, as well as the 3rd Circuit, the 8th Circuit, the 5th Circuit, and the 1st Circuit. And the Ohio Supreme Court has accepted a certified question in that state, query whether other federal courts will certify. What's as interesting is that in light of the numerous overlapping issues in these cases, a number of the federal circuits are consolidating these cases for oral argument. It'll be interesting to see if other federal courts will follow the lead of the 1st and the 11th Circuit in doing that. And another phenomenon that we're starting to see is a slight slowdown in the number of new rulings. And one has a sense that federal district courts are saying, the 1st Circuit is going to rule on this pretty soon. Why do I need to take the time to write an opinion on Massachusetts law when they're going to decide it for me? We'll see if that really catches on or not. Prognosis, I mean, only a fool looks in a crystal ball, but we can make some educated guesses. One thing that is apparent, this will probably not be the existential crisis that it looked like 8 months ago. There was a point around the summer of 2020 when insurers contemplated the possibility that every small business in America might sue them. Because the weird thing about this pandemic, unlike Katrina, unlike 9/11, it affected everybody. Part of that surge in the summer turned out to be due to the multi-district litigation petitions. The lawyers, the class action firms were trying to corral clients to inflate the numbers for Philadelphia or Chicago. But in fact, there's been a recent uptick in filings. I mean, you can see how dramatically the weekly filings dropped off towards the end of 2020. But there was an uptick in the last couple months, possibly due to the fact that some of these policies had 1-year limitations periods, and the insureds were being careful about preserving their claims. Unclear if that's going to continue. As far as the future goes, clearly insurers have done phenomenally well, better than we expected in the US district courts. But those of us who fought our way through the environmental wars and the asbestos wars that are ongoing know full well that what really matters here are the appellate courts, particularly state Supreme Courts. We've won the opening battles, but the outcome of the COVID wars are still uncertain. And with that, it's my great pleasure to turn the microphone over to Tom Baker. Tom is the William Maul Measey Professor of Law and Health Sciences at the University of Pennsylvania, where he's also on the faculty of Wharton. Before coming to Penn in 2008, Tom spent 10 years at the University of Connecticut, where he developed its Insurance Law Center. Most of us know him as the lead reporter on the ALI Restatement of Law Liability Insurance that he and Kyle Lowe guided to its final approval in 2018. Now, since the pandemic began, Tom has coordinated a team of students and consultants in preparing and maintaining the COVID coverage litigation tracker, which truly tracks the developments in this case law in real time. Tom's talk today will discuss some of the findings of that work and his own thoughts about the pandemic. Tom?
Great, thank you, Michael. And I'm going to try to focus on the sports and entertainment cases and close with some data from the tracker that we haven't released publicly that's going to be interesting to you guys, I'm sure. And then I want to hear from the other panelists. So I'll try to be kind of brief. So we've been coding the cases by NAICS code. And for the purpose of this presentation, we developed a way of sorting them by by NAICS code. And this slide just shows you which ones they are. And it's hard to, not all of these would qualify as Mike's big fish. I think I've got all the big fish in the net, but that there are plenty of little fish in the net too. So please understand that some of the data that I'm about to show you are a little messy, and I'm not 100% confident about the NAICS coding, but here it is. So we identified 89 cases that we think of as sports and entertainment. And if you notice, then I have American Indian and Alaska Native tribal governments. That's because it's I would say my informed impression that those cases are cases involving gambling. And for this purpose, I'm including gambling activities as entertainment. I don't think this is sport. And people could disagree with me about whether to include gambling, but certainly some of the gambling cases are going to be among. I mean, those are definitely big fish cases. So they're ones that are going to be interesting. And all right. So this is just a comparison of the, what's the picture like over time between the sports with the ones, the subset versus the mass. And I'd say it's the same picture that Mike described with, I would say, that is the more recent, the more recent uptick is more significant in relation to sports and entertainment cases. And those are big fish type cases that I'm sure people on this call were among the lawyers that were filing them. We have, for internal purposes, what we call a termination summary, which shows kind of how cases are melting. which is a term of art among the in empirical legal studies, with the melt of case congregations. And mostly what you can see is that the cases, the subset is melting less quickly than the mass, and I think that reflects the fact that the subset is not, doesn't have the kind of more local lawyers or the class action lawyers that that I know. I mean, they definitely filed cases to build up their chances of leading the MDL, which of course never happened. There are 10 cases on appeal that in the subset. Again, those are mostly smaller cases. Something that a lot of people are not as aware of as I really think that they ought to be, is that the insurers have been very strategic about motions to dismiss, and that there are a not insignificant number of cases in which the insurers chose not to file a motion to dismiss, or chose after losing on a motion to dismiss, getting it not to file a motion to dismiss again when they answered. So there's nearly as many cases proceeding where they've been answered as there are cases that have been voluntarily dismissed. So there's sort of choice. Let's say there's choices on both sides to either drop or to not fight the early stages of the litigation. This is the picture that I think that the COVID coverage litigation director has helped people understand the difference between state court and federal court and what's happening. I looked at our subset versus the mass in terms of whether there are differences in state court versus federal court. And mostly what I say these pictures indicate, there's just so few rulings that it's hard to draw any conclusions about the subset. I mean, if on the hand, that most of the bigger cases, I think the carriers have not filed motions to dismiss it, but we'll see. In federal court, again, hard to say much. You could say that superficially, you could say, oh, the carriers are doing better in state court in this subset than they are in the mass, and the policyholders is doing better in federal court in the subset in the mass. But I think mostly what I say about this is there's just too few rulings in the subset to make any real distinction about them. This is my favorite little box score thing that I just highlight for people. And this is not about the subset, this is about the mass. But when you look in state court, the runaway victories that the carriers are experiencing in federal court are not there. Then in fact, if you look at the sort of state court cases in which there's not a virus exclusion, the policyholders have succeeded in avoiding dismissal more often than not. One thing that we're thinking about doing, but it's complicated, is changing the presentation on the website so that we, instead of virus exclusion, yes, no, we have a bit more of a nuanced presentation where there's cases without a virus or broad communicable disease exclusion on the one hand, and then cases with let's call it an ISO flavored virus exclusion, and then in the middle of the cases that have the what we've been calling the hidden virus exclusion, or the contamination or pollution or other exclusion that contains the word virus in it. And I think that many of the wins for the policyholders in the left-hand side here, I think, are cases where it was a hidden virus exclusion, and so we'll have some insight into that in probably in a couple weeks. Finally, thing for this group, we've got a little tool where we can compare the results in cases by toggling who the policyholder lawyers are. And so on the left side of the screen, you see the results for cases brought by policyholder lawyers who do not have a commercial insurance coverage practice established. And on the right, you have the results for policyholders that do have lawyers who are experienced in the area. And you can see here that there is some data behind the intuition that experience matters. There are so few rulings in cases in which there are ACC members that the data are not, sort of not enough there to draw anything significant. So but it more or less is in line, and and I get a kick out of. I mean, I won't tell you, but half the people in this room can guess who it is that's included in the chambers ranked for insurance and is not a member of the ACC. It's, so far as I know, only one law firm, but I won't call that law firm out. So those are my sort of issues. I just want to remind people, what it is, what are we doing? We're mostly collecting data you can get from other places, but our, added value is to basically organizing it and tracking it across multiple sources. And then we're hand coding a variety of information that's not available anywhere else. And, we show some of that up on the website, but we'll, gradually hope to make more and more of that publicly available. And, what are the research methods? I mean, part of the, I would say our main objective is really methodological, like how, is it possible to do this? And, in the process, can we provide, objective, reliable information about the case? I think the first two we've done. And then now sort of looking ahead, I'm still working on how we're going to do this exactly, but there's been a chorus of people saying that the federal courts are not following Erie. That may or may not be true. I'm figuring out some ways about how can we objectively measure that. And I'd welcome suggestions from people about how to do that. I mean, one thing, one kind of simple-minded thing is we'll do some counting of citation, look at who the district courts are citing. And then other research objectives are, how do we identify those events that make a difference? Because, these cases are not, they're not, yes, they're individual cases, but of course the case congregation as a whole, all of them are affected by what happens in each of the others. And then finally, from a litigation risk perspective that would be of interest to, say, insurance companies or litigation funders, can we evaluate and update the evaluation of portfolios of cases within an emerging case congregation? And we're still working on that. And then a final objective is, I think that we need something to, we as a society need to be able to be prepared for the next pandemic. It's pretty clear that the private market isn't going to be doing that all by itself. And so, hopefully we can help be part of the solution and by providing data about it, or at least what happens in this round of litigation. So with that, I'll turn it back over to Mike for the real show. Oh, Mike, you're still on mute.
Thank you, Tom. I think your insight about the successful capabilities of ACC lawyers is absolutely on point. We're sure the data will bear you out. And thank you again for providing this resource to us. It's really been a great thing for all of us. So we've got the big picture. Now let's move on to the specifics of sports and entertainment, or fun and games, as I call it. What is it that's going to be different about these cases other than their size? What are the issues that are going to be litigated other than things like direct physical loss or virus exclusions? We're going to start with a panel on entertainment, and to present are Laura Foggan and Anamay Carmel. Anamay is subbing for Kirk Pasich. Anamay and Laura are from opposite sides of the country, and I dare say they have opposing viewpoints too, but you can judge for yourself. Anamay is a founding member of the Pasich law firm and chairs the firm's entertainment insurance group in Los Angeles. During this pandemic, she's been one of the go-to lawyers on the West Coast as studios, recording artists, Broadway producers, concert promoters have scrambled to figure out whether there's coverage for COVID losses under film and TV production, event cancellation, non-appearance, GL, contingency, and property insurance policies. In her spare time, she's the co-editor of New Appleman Sports and Entertainment Insurance Law and Practice Guide, which is a great thing to read if you try to go to sleep at night. Laura Foggan is the chair of the insurance practice group at Crowell and Mooring in Washington, D.C. She's Chambers ranked and included the best lawyers in America and was Lawyer of the Year for 2020. That's a tough thing, because if you're not in 2021, what are you? During the pandemic, Laura has really played a leading role in advising insurers and coordinating litigation about the pandemic. And most recently, she's has been the lead author on the briefs that the APCIA and NAMIC have filed in various federal courts of appeal in major COVID appeals. So Laura and Anamay, take it away.
Thanks so much, Mike. And before we go further, I want to thank my alma mater for sponsoring our webinar today. And Anamay actually is going to talk through some of the issues to start us off, and I'm going to offer some commentary on her thoughts.
Thanks, Laura, and thanks, Mike. Yeah, we are going to talk through some of the types of coverages available in the entertainment industry, as well as some of the key issues that have come up in the course of the COVID litigation. I think I don't have control of the slides, so if we want to go to the next one, we can jump right in. We'll start with the insurance for the motion picture and television industries. And, you know, what's interesting about these types of cases, and Tom touched on this, is that we're outside of the realm of this requirement of direct physical loss or damage. So there's a small aspect of that in the majority of these policies, but really we're focused on, you know, delays and disruptions caused by other things. And so a lot of the decisions have still, or court decisions have yet to be made on some of these issues. So we can go to the next slide, please. In the motion picture and television industry, we're looking at usually portfolio policies, sometimes individual production policies, and really the coverages are, you know, there's a portion of it that covers property damage, but there also is cast insurance, which insures against losses suffered by the inability of key cast members to appear in productions or to appear on set, usually illness, accident, death, things like that. There's also extra expense coverages, which are, you know, supposed to cover the losses incurred by the delay caused by either actions of civil authority. These are when actions of civil authority impair the ability of a production to proceed. Travel delay, ingress, egress, when the ability to access a location is impaired, and imminent peril, when there's such an impending danger and the danger of it has such a high probability that it would be unreasonable or unconscionable to ignore any potential or injury or damage to persons or property. And then finally, oh, go ahead, Laura.
And I was just going to say, to reinforce what Anamay started out with, that these are package policies. They do contain traditional property coverage, which does require direct physical loss or damage, but they contain additional coverage parts. And those additional coverage parts, importantly, may not be tied to the direct physical loss or damage requirement in the way that we see that requirement in the forefront as a linchpin of coverages, for example, under commercial property policies in widely used language. So I think that's really part of the key here, that these extra expense coverages in particular may not be tied to the direct physical loss component.
Yeah, I think that's right. There's also an interesting provision in most of these policies called the due diligence provision, which requires policyholders or the insured to act prudently and do what it can to avoid or otherwise diminish a loss. There's one of the questions that's come up multiple times is, you know, what's the extent of this requirement and what does it mean in terms of how much the insurance company is required to pay? I mean, obviously, I think these provisions are in place because, you know, we want to discourage, or insurance companies want to discourage the, you know, potential abandonment of a claim. And when faced with the cost of abandoning a claim versus the cost of, you know, extra expense caused by a delay in production, there's a pretty steep difference there. And so any effort, I think, to reduce the chance that production will actually have to be abandoned or, you know, deserted altogether versus versus productions that can later be reshot or, you know, they can still go forward is a big factor in place. And so a lot of these policies require the insurer to actually pay for losses incurred by the insured in efforts to avoid or mitigate a loss. Okay, I think we can go on to the next slide, please. And so the next couple of slides kind of goes through some of the key issues that we're seeing being played out in discussions between the two sides and also in court. the first is kind of touches upon what I was just saying about the due diligence provision. I mean, while cast insurance coverage typically comes into play when there's an actual injury or there's an actual something happens to a key person involved in the production, a question becomes, well, when you're protecting that person and you're avoiding something worse happening to that person, i.e. a COVID infection or death or something, you know, when you're protecting that person, are there insurance dollars in play there? Laura,
I think, yeah, I think that's a really interesting question. And you know, as we've commented, there isn't case authority on it yet. But, you know, I think there will be analogies that are made to other situations where there are mitigation expectations in insurance policies. And there will be questions about whether, you know, due diligence is, you know, a covered expense, where mitigation isn't of something that is highly certain to occur. And so there are a lot of questions here about how likely is it that COVID would be on the set, that someone would become infected, that this would implicate you know, a need to take steps to protect the cast, and in what circumstances it would implicate that need, given that, you know, many of us, you know, are operating in a variety of ways with the problems and challenges of the pandemic every day. And of course, those same expectations would exist for the policyholders here. So there are some interesting questions about how that will play out.
Yeah, exactly. I think there's definitely protections that can be made, but you know, when you're talking about a film set and you're talking about needing to create something where you don't necessarily have the benefit of some of the protections that we've all come to rely on, like working from home or wearing masks or having, you know, personal protective equipment in place. And also, you know, reducing the amount of people that we're exposed to. I think that the situation on set of a movie or a television production definitely creates a unique environment. So you're right, there are going to be some interesting questions there. The next point, I think, is sort of the same idea, is how much of an imminent threat or imminent peril SARS-CoV-2 presents. And so obviously, you know, insurers and insureds are taking very different approaches to whether or not the spread and threat of SARS-CoV-2 constituted a real problem for people who are on set. I think, Laura, did you want to comment on that?
Yeah, I mean, I would just say same kinds of questions, and in response to some of your observations about the fact that the same precautions that many of us are able to implement by working at home and wearing masks and so forth may not be applicable, that, you know, this is also true in other contexts where it's been addressed through other mitigation measures, creating a bubble, you know, addressing, you know, testing and other steps to, you know, permit the production activity or sporting activity or whatever the activity is, school attendance, to go forward.
Yeah, I think that actually gets into a later question of, then it becomes whether the cost to create that bubble and to create those efforts, whether those constitute covered losses under these same types of policies, right?
Yeah, absolutely. Are they business expenses? Are they really something unique that's being done as you know, a due diligence measure to prevent imminent harm?
Yeah. Okay, some other key issues under these policies, and I think, well, the next one applies to not just to motion picture and television, but also to the whole entertainment industry, is really what is the loss or occurrence. I think there's differing viewpoints on this as well. For example, if you have a production that's set to shoot in different countries all over the world, they obviously have different orders that are effective them. They've had different responses to the pandemic, whether there was a national response or, you know, something like in the United States where it was done state by state, city by city, sometimes town by town. Really, if you have all these different orders and issues affecting you in different parts of the world, is there one occurrence? Is there one loss? That's definitely a question that remains to be seen. How many coverages apply? Likewise, there's we just went through the various types of coverages under the policies, and the policies don't have language that specifies that if, there's a civil authority order, that's only that coverage can apply at the exclusion of other types of coverage, like the due diligence provision or other types of extra expense that might have been incurred.
Yeah, and I think we'll see some questions in that regard because, we know that policyholder advocates will flag all of the potentially applicable coverages in the policy as something to be explored. And so it's likely that there may be some questions about duplicative claims and how the coverages interact if coverage were to be found under any of those provisions.
Right. Okay, and then finally, another question, or I think there's one more slide here, but another question that we're seeing being litigated is traditionally these types of policies tagged onto the productions themselves. And when I say traditionally, I'm talking about the custom and practice of the insurance industry, specifically for motion picture and television productions, that the policies were designed to apply to the production rather than the time period. And they were typically extended to include the time that it takes to finish a production if it had been delayed. But now we're seeing productions that were delayed because of COVID or for some other reason during this period that have the time to restart those productions happens to fall outside of the original time limit that was thought it could be done by the policyholders. So a question really will become, or one of the questions that's currently being litigated in multiple lawsuits is whether or not this custom and practice of extending the policy to attach to until the production can actually be completed remains to be seen.
Right, and of course we would politely dissent from the characterization of that as a custom and practice as opposed to something that's been negotiated and agreed in certain cases based on the facts and circumstances of those cases. But having said that, I do agree. I think there are going to be some questions raised about, the circumstances in which policies are extended and the addition of exclusions for communicable disease in future policies.
Right, which leads to the next point of whether an insurer can add can use the pandemic or COVID to add an exclusion after a cast medical examination. So the way this works is in order to obtain cast coverage for declared or essential elements of a production, that actor has to undergo or crew member has to undergo a medical examination in order, and based on that medical examination, the insurer will come back and say whether or not certain health issues exist and whether or not there has to be exclusions put in place. But what we've seen is insurers come back and say, well, this person's perfectly healthy, but we're adding a COVID exclusion, even though has nothing to do with anything specific to this particular cast member. So that's another question that remains, the answer to which remains to be seen, whether or not that's proper to do.
Right. And the next question is going to talk about losses a little bit. And I think there's a big picture point about what the policies cover and what they don't cover that we should touch on. And that is that, generally speaking, the entertainment package policies that I've seen are responding to the costs of a delay in the production. And they are not responding to all income losses. And there may be other very substantial income losses, and particularly when we talk about some of these big entities. Now, they may have specialized provisions in their policies, but there's a difference between actually producing the film or TV content and the ability to distribute it, the broadcast rights, the other kind of follow-on interests that can dramatically impact the income stream of some of these policyholders. And we may see some very interesting questions if coverage were to be found, what it is, what the damages are, and what the scope of that coverage would appropriately be.
Yeah, there's other questions here as well. Questions like, well, someone, when a production can come back and they can come back and reshoot everything that they were unable to do due to the original COVID shutdown, but something else happens. Now you're in a chain of causation events. And so real questions about what the like why is the production in this place now will come into play as well, and whether that triggers additional coverages that may not have been triggered by the original COVID shutdown. It's really what we're going to see attributes, what we're going to see as the cause of those loss, and how the loss is attributed to is going to affect definitely the amount of recovery under these types of policies.
Yeah, and then similarly, the last question here goes back to a topic that we've touched on as well, which is the line between business expense and what qualifies under the policy as extra expense. And, you know, if you need to comply with mandatory COVID safety protocols in a particular location, you know, that's just what the regulations and the law requires. Is that just a business expense, or is that now something that would be, you know, extra expense under the terms of the policy?
Right. The language of the policy is definitely something that's going to come into play here, and to see whether or not how the policy addresses the difference between business expenses and extra expenses.
Yeah, agreed.
Okay, I think we can move on to the next slide, please. The second sort of bucket of policies that we were going to address are disruption, non-appearance, and event cancellation policies, because even though, so the motion picture and television industry have unique sets of policies, and when we're talking about things like concerts and theaters or theater productions, touring productions, those types of things have a different sort of, have different unique policy language that applies to them. Next slide, please. These types of coverages, as we said, performance disruption comes into play. Mostly, we've seen it mostly come into play in the Broadway space for theatrical productions that were delayed. Again, none of these types of policies, except for perhaps theatrical property and loss reduction, has any sort of connection or requirement for direct physical loss or damage. And so since the pandemic started, we've seen the performance disruption policies typically are pretty straightforward, and there hasn't been much controversy about whether or not claims should be paid under performance disruption policies. I think the key issues tend to be what gets brought into the claim, what costs are considered part of the claim. Event cancellation policies are, since they're typically ensuring capitalization costs or profit, or sometimes expenses as well that are incurred. So we've seen some of those have different types of exclusions that may come into play, as well as different types of coverages that also come into play. I think that non-appearance policies are those policies that insure against losses similar to cast insurance in the movie and TV space. Non-appearance policies are typically tied to a particular performer and cover losses that are incurred for various reasons why that performer couldn't show up. And then loss reduction policies, similar to the due diligence clauses in the the motion picture and TV policies, loss reduction policies or provisions in policies also can be triggered by the efforts to reduce or avoid the amount of a loss.
Yeah, I think that's a good overview, Anamay, and I'm actually going to defer here because I know that there is a later panel on event cancellation that will probably touch on some of the issues there in more detail.
Exactly.
And we want to allow them to address that and save them the time to do it.
Okay, that sounds good. So moving on to some of the key issues that are coming up on the next slide that we're seeing with these particular policies, very similar to the motion picture and TV area, whether or not non-appearance or cast coverage is triggered because reasonable steps have been taken to protect the cast members, whether they're required or whether they're by law, whether they're agreed upon by the various unions, is one of the questions that remains. Secondly, do orders in different geographical locations separately trigger coverage? This is, in this space, we're talking mostly about tours. And we've seen tours by recording artists be canceled. We've seen tours of theatrical performances be canceled. And so whether or not each geographical location has to have a specific order that's tied to that cancellation, or whether or not the insurers are treating the entire cancellation of the entire tour as one loss is a question that will be litigated. Same question, same issue for the next point is whether each engagement or event is entitled to separate limits. This also applies in the touring space. Finally, did you want to say?
I was just going to say on those two, they're really interesting questions because on the one hand, there isn't a lot of precedent because we haven't seen the context of a pandemic where multiple locations are impacted at the same time by, the same pandemic circumstances. On the other hand, obviously there are individualized facts and circumstances in different geographic locations that also, could come into play in that analysis. But historically, if you looked at, touring company cancellations or changes, there aren't that many factual scenarios in prior case law that would appear to be directly applicable here.
Right. Okay, so let's move on to the next slide. These are some of the additional key issues. I know our time is wrapping up, and that there is an additional panel on the event cancellation issues, but we just wanted to highlight these so that people know what to keep their eye on as litigation comes through the courts. Some other interesting questions are whether or not how the government grants, there was just the Save Our Stages grants that were just given, how they affect insurance recoveries. And obviously, there's no duplicative recoveries that are intended, but because there were government grants given, it'll be interesting to see how insurers treat those government grants.
Yes, and I think that's an issue that does cross over between the entertainment area and other areas as well, because just as we have Save Our Stages, we have, Save Our Restaurants, we have Save Our fill in the blank, a series of governmental programs, state and federal governmental programs that have permitted businesses to obtain grants and oftentimes even for forgivable loans to address some of the economic hardship of the pandemic.
Yeah. Okay, I think that's probably about it. And so I guess we'll see you all later for questions. Thank you.
Quick question. That was terrific. Quick question for the panel. Are there territorial limitations in this coverage? If a U.S. studio suffered a loss because they had to shut down filming in Italy, would it be covered?
It depends on the policy. If the studio knows that it's shooting in Italy, they'll have ad endorsements to add Italy to the policy.
Yeah, generally they can be worldwide.
Yeah.
Great. Well, thank you both. So let's move on to sports. There were, in fact, early sports suits in the fall. The Chattanooga Major League Baseball team, minor league baseball team, the Atlanta Falcons, the Philadelphia Eagles, but it's really snowballed since then. And most recently, Major League Baseball has filed a major action on behalf of both the league and the individual teams. It's pending in state court in California. Here to talk about sporting claims are David Goodwin of Covington and Burling and Linda Sue of the Selman law firm. David is a partner in Covington's San Francisco office. And according to Law 360, he's one of the three most valuable players in insurance litigation, which makes him perfect for this panel. And in fact, he's lead counsel for MLB and the DJ that I just mentioned. Linda is the managing partner in Selman's San Francisco office. She's been handling major coverage of bad faith cases on the West Coast since 1994, and most recently achieved a landmark victory for the insurance industry on the issue of recoupment in the case in the Nevada Supreme Court. So Linda, David, let's have at it.
I wonder if David is muted because he's supposed to go first.
Sorry, I am muted. Thank you. I'm going to go first. Linda's following. Could we move on to the next slide, please? assuming that Pearl has the slides. There we go. So if we can go back in time to the 11th of March of last year, that was the day in which it was announced that I believe 5 members of the NBA tested positive for COVID-19, and I believe it was the Knicks basketball game was canceled. And that following weekend, I think everyone knew that the basketball season was coming to an end. Baseball suspended its spring training. And the country essentially went through a 5-month sports drought. And at least for some of us, it was very difficult to sit through, not having our local sports teams and sporting events. And as the first bullet point on this slide reflects, professional sports are a non-essential business. So they had no basis for remaining open, at least initially during the pandemic. And the losses that they incurred are pretty straightforward. If you're not playing games, don't have people in the stands. You don't have advertising revenues. You don't have people buying concessions in the ballparks. You don't get your TV revenues. Most sporting teams attempted to mitigate their losses by renegotiating their contracts. And at least in baseball and basketball, I believe the unions were pretty firm in minimizing the reductions. So the baseball teams were losing money. So with that background, we're going to turn to the insurance claims that arose out of this. I think one thing to bear in mind, and I know it's been touched on a bit, but I think it is an issue that divides insurers and policyholders in presenting on COVID-19 issues quite meaningfully, which is that there are major differences between insurance policies and insurance policy forms. And having looked at quite a number of sports teams' insurance policies, I can confirm that that's true within the sports world as well. I was on at the RIMS conference last month. I was on a panel with the risk manager from General Motors, who really liked this analogy. I explained that the ISO policy, which is probably 95% of the lawsuits on Tom Baker's chart, are the Chevrolets of insurance policies. And Affiliated FM and Zurich Edge are kind of the Oldsmobile of insurance policies. And the Factory Mutual TE Select form or the equivalent are kind of the Cadillac of insurance policies. And the teams that have made claims under their insurance policies have that range of insurance policy. As this slide reflects, there is a common issue to almost all of the claims, not every single one, but almost all, which is there physical loss or damage to property? So let's move on to the next slide, which is a summary of at least some of the current sports claims. Now, as Tom indicated, the very first sports-related COVID-19 cases were filed by minor league baseball. And some of them were filed, some cases I believe were filed by a league or leagues, and others were filed by individual teams. And again, this is an example of some had a Zurich Edge or an affiliated FM policy, some had an ISO policy. I believe everyone that's gone to a decision has had a virus, the ISO virus exclusion or the equivalent. And minor league baseball is very different from Major League Baseball because most minor league teams have no sources of revenue at all other than selling tickets. So if they're not open with fans in the stands, they're not earning money. Major League Baseball obviously is different because they have television rights. So again, these as whenever you see the words business income, you know that it's an ISO form. And as the second bullet point says they were seeking coverage under the business income forms. There have been, I believe, at least one case resolved in favor of the insurer, and one where a motion to dismiss was granted with leave to amend. There are still Major League Baseball, which is my firm's client, and I'm obviously not going to give away any confidential information about it, but I can say that it filed its lawsuit in October of 2019. That the complaint was filed in Alameda County, California. There are more baseball teams in California than in any other state, and more insured properties under their policy than any other state. What Major League Baseball did, which is different from some of the other leagues, is that it has one insurance program covering all 3 clubs and then the other Major League Baseball operations. Minor League Baseball has some common insurance policies, but most of them are individual league or individual club policies. The same thing is true with the NBA and the NFL, I believe. So the Major League Baseball alleges in the complaint that COVID-19 was physically present at every ballpark. And one thing that you see in these sports-related COVID-19 claims is that you're dealing in very large part with young men aged between about 19 and 30 who have a lot of money, not a particularly good education, and really, especially early on, did not take a lot of precautions to avoid contracting the virus. And so there was a host of COVID-19 claims among the Major League Baseball teams early on. And the complaint in the MLB case cites to a number of scientific studies about COVID-19 and its properties. Okay, next slide, please. And then in addition to these, this is a partial list of the current sports claims. I don't think it's far from a complete list. But for example, in the football area, the Atlanta Falcons have filed a business interruption case, and I believe that they actually have coverage from Factory Mutual rather than from Affiliated FM or one of the ISO insurers. And they allege that they had both direct physical loss on their properties and they allege loss of revenues. We then have seen at least 3 NBA teams that have filed COVID-19 coverage actions, first being the Houston Rockets. And they argued that, I'm not sure that they actually alleged that there was on-site presence of the virus, but they alleged that the government orders were the cause of their loss or damage. The next one was the Los Angeles Lakers, and I was rather surprised to see that they sued in Los Angeles against Federal Insurance Company, because that means that there's diversity and they're in federal court, and the federal courts in the Central District of California have been uniformly rejecting the COVID-19 coverage cases. But they had a very sophisticated argument in their complaint as to why they would have coverage. One other NBA lawsuit that's not on the list is the Sacramento Kings lawsuit against Factory Mutual again, and FM has filed a motion to dismiss. I should mention that in the MLB case, the insurers did not seek to dismiss the case at the outset. In California State Court, it's called a demur rather than a motion to dismiss, but they answered the complaint rather than moving to dismiss. And the judge has asked whether there is a possibility of filing early summary judgment motions, which is an issue that's in discussion. Now I will turn it over to Linda.
Great, thank you. If we could go to the next slide, please. Great. So I'm going to talk a little bit about some of the relationships between sports claims and the entertainment disputes as we've been talking about. First, in some sense, the disputes, insurance disputes in the sports and entertainment industries are quite similar. It all depends on what types of policies these entities have, as we've been talking about, to the extent that, for example, minor league baseball and perhaps some entertainment risks use the ISO form. The focus is going to be on those ISO endorsements, and physical loss or damage is going to be a big issue. There's also the fact that sometimes entertainment and sports events are held at the same venues, sports venues for, say, concerts, that sort of thing. And so there's some similarities in the types of losses that are being suffered, ticket sales, as opposed to perhaps a little more unique to the sports industries, some sponsorships and things like that. And then also, as venues reopen, both sports venues and live entertainment, theaters, theme parks are going to have to make decisions regarding capacity, spacing, mask usage, that sort of thing, which kind of has some similarity between what Anamay was talking about with respect to due diligence clauses in some of the entertainment policies, and then perhaps some, mitigation type conditions that you see in a more typical ISO or sports type of policies. And also, I think location is going to be, create some similarities and some differences. So, California has been, or certain parts of California have been, much more conservative when it comes to protecting against COVID than in other parts of the country. So there might be some similarities or differences there. One issue that I've seen, especially when you're comparing ISO policies to more manuscripted policies, are issues of sublimits and aggregates. As was pointed out earlier, some policies may have a sublimit for, say, ingress, egress, or for imminent peril, but they don't have an aggregate limit, whereas a typical ISO policy usually does have an aggregate limit. So some of these claims, depending on whether they're sports claims, entertainment claims, or the types of policies that are at issue, might have larger losses if coverage is found in first place. And then also, I think there are some, the entertainment and sports industries can be very different. Some might dispute this or have a different opinion on it, but there's a difference. Even before the pandemic, people were perhaps more willing to stay home on their couch and watch a movie than they are to go to a movie theater, as opposed to a sports event. I mean, of course, people watch sports at home, but there's something about going to a basketball game and being among the crowd, as opposed to, you don't necessarily want to go to a movie theater. So there's going to be just some differences, I think, in damages if the insurance or the insureds can, get past motions to dismiss. So the pandemic has forced industries to get creative in terms of finding different ways to engage with different forms of entertainment and that type of thing. There's actually a really interesting article today in the New York Times about, I think the title of it was "When COVID Dropped the Curtain on Broadway Actors, TV Kept the Lights On." So if you're interested in this topic, I thought that this article was really interesting. I'm sure you could just Google it. It kind of talked about actors in the Broadway industry that maybe have also had success in the TV industry and how that's differed. So also, I think some similarities that we'll see will involve consumers may still be fearful about large crowds, even if they've been vaccinated or even if restrictions are lifted. Those are some, interesting things that we're going to see coming up, I think, in the litigation context. Again, if we can if insureds get past motions to dismiss. If we go to the next slide, which talks about interesting notes about sports claims. So as it's been pointed out, there's already been one minor league baseball case that's been resolved in favor of insurers due to the presence of a virus exclusion. And also efficient proximate cause issues. So, was the shutdown caused by the virus and therefore a virus exclusion applies? Was the shutdown caused by action of civil authority? And so I think efficient proximate cause issues are going to be addressed even in non-ISO related policies. And finally, having a problem with my computer, sorry. So as we've already talked about a bit, losses in the industry are going to vary depending on when they're allowed to come back and whether or not certain entertainment venue or entertainment productions are going to be canceled or abandoned altogether versus whether they're going to come back to some limited or full capacity. And then what I think is going to be interesting too, finally, is whether or not we're going to start seeing more lawsuits and litigation brought by industries that are connected with entertainment, and particularly sports industries. You've got your vendors, your concessionaires, your restaurants, and so on that are close to the venue that have obviously suffered major losses. So I think those are what we're going to be seeing, particularly in the sports arena. And so I think my time is up. So with that, I will turn it back to Mike.
Thank you very much, Anamay. I did give up my Red Sox tickets last year, and it turned out to be an excellent year not to go to the ballpark. But hopefully we'll all get back there someday, because you're right about the movies versus sporting events. For our concluding panel, we're moving on to event cancellation, which is an issue that's been out there for a long, long time, but it's really been brought to the fore by the pandemic. And I'm sure we all read about the windfall, maybe not windfall, but the great good fortune of the All England Lawn Tennis and Croquet Club of buying event cancellation coverage when, for the first time, they had to cancel Wimbledon in 2020 and received a $100 million check. That board member is richly rewarded for his foresight. Not all policyholders have been as lucky, and there are a lot of different claims that have arisen with event cancellation that are particularly pertinent to the two panels we've just heard, because as you've heard, a lot of sporting teams own stadiums, or there are conglomerates that have both hospitality and sporting and entertainment aspects to it, where events are being used for conventions and other events that have had to be canceled during the pandemic. Here to discuss the ins and outs of event cancellation are Sherry Pastor and Steve Pate. Sherry is the president of the American College of Coverage Counsel and chairs McCarter and English's Insurance Recovery Litigation and Counseling Practice Group. Among her many but more noteworthy victories was a $16 million verdict for Wakefern Group in New Jersey, which is the key case that policyholders are relying on and trying to get direct physical loss coverage in New Jersey for COVID claims. Steve is a senior partner with Cozen O'Connor in Houston. He is a member of our Board of Regents at the college and active in groups like ABOTA and the American Law Institute, as well as being recognized by Chambers USA, and he knows more about Texas history than anybody I've ever met. Sherry and Steve.
Thanks, Mike. So if you'll go to the next slide, please. As everyone knows, and to state the obvious, many events, music, theater, sporting events, expositions have all been canceled in the wake of the pandemic. And so what we're going to talk about for the next 15 minutes is event cancellation insurance. And as many of you know, that is intended to protect the revenue stream for these types of events. It's to protect the visibility of the organization that puts on the event and its reputation, and also to help protect, many of these events are year after year events or serial events. So in terms of the coverage, I think that, the first issue is going to be, is there a trigger of coverage? And I probably ought to mention that, in terms of this type of coverage, what we're hearing from the insurance industry is that this coverage is going to be an important and expensive expense for most of the insurers. At least the last time I read, Swiss Re was suggesting that it expects it could be an $8 billion issue. And Swiss Re's got about 15% of this global market. So the first issue that's going to come up in this area is going to be the trigger. And I have to tell you, from the policyholder perspective, I see this as less likely of an issue. We're talking about a pandemic. These policies, although they are not off the shelf, they're manuscripted, typically have language like that, which you see in the slide. And the trigger is often that the insured event, whatever it is, needs to be canceled or abandoned or postponed or interrupted or curtailed. And it's got to be solely and directly the result of an event that is beyond the control of the insured or their agents. I don't think we're going to see in this context what we've seen in the past in terms of litigation about, issues around that sole and direct result, at least for events canceled early in the pandemic. You may remember there was a lot of litigation in this space after 9/11 about, did somebody in California really have to cancel an event because of what happened in New York? You're not going to see that here, where you're talking about an event, a pandemic that was global. Now, where you may see some debate is around this beyond your control, at least, when you get further into the pandemic. I would say, though, early on, a pandemic, I think we should all be able to agree, is beyond the control of those who are sponsoring these types of events. This isn't a situation where I think insurers are going to debate a lot around, what kind of control could you have had around the event and the measures, except as you get further into it. And when you look at the policy language, whether there are exclusions that are going to go to things like, was there an order in place that prevented you from going forward? Could you have gone forward legally and safely with some lesser number of participants, things like that. But, I will say and should remind, there is very little coverage litigation around event cancellation as yet. And so I may be proven wrong. Steve, what do you think on trigger?
Well, I think that, let me go to your last point. As you and I discussed, there just isn't any real coronavirus case law or cases filed on event cancellation now. And when I get to the next slide, we'll discuss that a little bit more. There's one in Houston that is actually not a COVID case. It's a policy replenishment excess case. But beyond that, after a year, with all these events that have been canceled, there's just not litigation. I'm not sure there's going to be litigation, but to your other point, as far as trigger, I think that trigger is pretty much a done deal. That the coronavirus trigger in certain contexts, you can say COVID did trigger cancellation. I don't think that's going to be a big deal. The issue goes on from that to whether it's covered or not. Are we ready for the next slide, you think?
We are.
Okay. Now, there are certain exclusions that show up in event cancellation insurance. And we'll talk about the big enchilada, so to speak, in the next slide. but we've got acts of terrorism or war. That's pretty much a given. Financial failure, we don't, no insurance carrier can really insure for a company going bankrupt, not being able to pay Mick Jagger to show up. Failure to pay necessary arrangements, once again, that's a pretty solid exclusion. Non-appearance of any person other than the key person, that is a pretty solid exclusion too. Those are what you seem to see in event cancellation insurance. Once again, I don't think that those exclusions are really going to be relevant to COVID cases. Do you think, Sherry, that that's the case?
I hope that you're right. I don't think that we're going to see a lot of those types of challenges by the insurers, at least early on. I wonder if as the pandemic moved on and events were canceled in the fall or later, whether we're going to start to see some issue around, causation and whether there was a financial failure or a failure of support as opposed to the pandemic. But I'm hoping that that you are right and we don't see a lot of fights around it. We certainly have not seen them, at least in my experience, yet in this setting.
Let's go to the next slide. This is what I just called the big enchilada. And I'm glad Mike mentioned my love of history. And when he mentioned history, it struck me. He talked about the windfall for Wimbledon. And I thought back to the 1906 San Francisco earthquake, where Lloyd's of London had many policy exclusions that would have excluded all sorts of coverage for earthquake losses, and they didn't use them. They didn't use them. I don't know too much about the Wimbledon situation, but I'm wondering if that was more or less a situation where the insurers said, this is so important to our nation. Yes, we have some coverage problems, but we have to do this. I don't know, but I'm kind of thinking that there was something like that that occurred. What you see in many, many event cancellation policies, and something that before last year, nobody ever really talked about or noticed, was the communicable disease exclusion. And what we've got here is a version of it. There seems to be a CGL ISO communicable disease exclusion. I have not found a property ISO exclusion after what I thought was diligent search. They all seem to be manuscript. The ones I've found are all pretty much this sort of language. And let's look at the language for a second. This insurance does not cover loss directly or indirectly arising out of, contributed to, by, or resulting from any communicable disease, which leads to an imposition of a quarantine or restriction of movement, people or animals, any travel advisory, and any fear or threat thereof. Now, this insurance excludes loss directly or indirectly caused by, resulting from, or in connection with any action taking and controlling, preventing, so forth and so on. The key here to me is the language directly or indirectly. Then also arising out of, contributing to, or resulting from. Anyone who does insurance law knows that those are the key phrases for making an exclusion as broad as possible. And whoever drafted this was well aware of that. They didn't want there to be any question that communicable disease was excluded. Other point is, look at the language: imposition of quarantine or restriction in movement of people. Somebody had a crystal ball because they saw exactly what was going to be coming with the pandemic. So I think that this exclusion is very strong. And my thought on event cancellation insurance is there are not more cases because of this exclusion and because policyholder attorneys look at it and say, there's just no way we can get around that. You might try, but once again, we don't see any cases on it yet. Now, when I say that, there's another reason that there are not more event cancellation cases, because of the write-backs, and I'll let Sherry talk about that.
Yeah, I would say that the reason that we're not seeing, or we're seeing claims being paid in this space and being adjusted in this space is these policies are highly negotiable, and many of the policies do contain write-backs, so that where the base policy may have an exclusion for terrorism or communicable disease, there is an endorsement that will say it's deleted. I guess the other question that I would have in this setting is also going to be around, ultimately, if there is a debate in this space, is there going to be some discussion and consideration about an anti-concurrent causation provision? You know, do these exclusions form a list that begins with something that addresses where there is a combination of covered causes of events, how that will be treated? But I think the most important thing is that, you know, what we will see is where a policy does not have a communicable disease exclusion. I think the fight will be in the same traditional space where we've generally seen fights for these policies, and that's going to be in the mitigation space or in connection with other insurance provisions. So if you go on to the next slide, what we have seen in a lot of these policies are that there are provisions about what the insured must do to mitigate their loss. And a lot of these provisions look similar to those that you see on the screen. I will also say that in this space, although these are highly negotiable, where I see policies that haven't been negotiated and are more traditionally offered to larger groups of insured, you do tend to see language in them that is insurer favorable. Things like you got to do absolutely everything necessary to avoid your loss. You've got to make your absolute best efforts to rearrange the event. You have to, if we raise the exclusion, you know, the burden is on you to prove that it doesn't apply. That type of language can be more challenging. I think where we may see some issues in this space relate to things like, does a policyholder have to use some sort of a virtual event? Does it have to do something smaller than what it had planned? My suggestion to policyholders out there dealing with these kinds of provisions are, if you start hearing that you're supposed to do something virtually, etc., I would look at your enhancements in these policies. They often contain coverage enhancements. So I would argue that if I have to do something virtual, that's something that's an extra expense that gets paid to me to continue my reputation, to prevent me from losing revenue, and not necessarily something that an insurer can use to avoid or reduce the amounts that are due to me. Particularly where it's an event that repeats itself and is serial year after year, day after day, season after season. What do you think, Steve?
Well, my thinking is that your point about virtual events is dead on. I'm also thinking that in the next year or so, we are going to see circumstances where events are going to be held again, but there are going to have to be certain precautions. And will a carrier, and I'm just speculating here, they said, well, you could have done this not only virtually, but you could have done it in person as long as you required everyone who came to be vaccinated, or if you told everyone they had to wear a mask, or they, told them that they would have to socially distance. Now, we know that that would probably lessen attendance, but you could have done it. And that was part of your obligation to use best efforts to rearrange an insured event to mitigate loss. I'm speculating on that. There are circumstances where I can see that being part of these conditions of mitigation. Back to you, Sherry.
All right, why don't we go to the next slide, please? Because I think where the real issues are going to develop around this coverage are in the measurement of loss. I do think that there is investigation and measurement going on, but these provisions in terms of what the coverage is somewhat non-traditional. And in terms of the provisions, they typically cover irrevocable expenses. And so what that means, at least in terms of some of what we're already seeing, is insurers asking things like, show me the receipts, show me the contract. Could you have gotten out of the contract? Was there a force majeure provision that you didn't take advantage of? So I do think that we're going to see that. I also think because a lot of these cover loss of net profits, less any savings, that there's going to be debate around and continue to be debate around what does that mean? How far back does an insurer look? Does it have to look at your profit and loss statements for 1 year? Does it look for 3 years? Does it look for 5 years? As you may know, there's already one suit pending that is far from done. It's pending in California. It's the Emerald Holding case where, the very issue is, does the insurer in that setting get to consider corporate overhead savings in coming up with, what was lost or what the net profit is? So I think that could well be where we see issues. I'd also, though, remind that, a lot of these policies, when they're talking about refunds, refunding ticket sales, refunding, the fees that are paid by those for attendance, there will often be a separate paragraph that speaks to the fact that at least those refunds, you don't have to be obligated as a policyholder to return, whether you're obligated or not. If you make the refund or give the credit, that you should be reimbursed for it. Because again, the very intention of these policies, the reasonable expectation of the policy holder is that their reputation is being protected. So if they keep somebody's money and then don't have an event, they will not likely see that policy holder again, or that attendee again. And so it's important that that they make the refunds. Steve, what's your thinking on the measurement issues?
That's really that. Well, it really isn't even a COVID issue, is it? It's something that will show up in every event cancellation claim. The measurement of loss. Of course, now it's going to be attenuated. It's going to be probably you're going to because of the nature of the pandemic, you're going to have to look at it differently. It's going to be hard to really quantify any savings you were able to make in this circumstance. And, but more, it's a full employment act, full employment situation for accounting firms and for experts who will opine about lost profits. I just don't see this as very COVID-centric. That's something you get in just about any event cancellation circumstance. So if the cases start to come, we'll have to see what's unique about that. And by the way, Sherry, you made my day by using the phrase reasonable expectations. You know, on our side, we hate that phrase.
I'm glad that I made your day, Steve. Well, I think that in terms of, the issues that we're going to see, those are the issues that we're going to see in this space. The tendency in this space has been that there's been very little litigation. And right now it's premature to kind of predict what we're going to see and how it's going to turn out. But I'm fairly confident that at least in this area, we're going to see payment of losses because the issues are not the traditional physical loss issues that we see elsewhere.
Unless you've got a communicable disease exclusion that you did not get an endorsement to take care of. And then I think it's, I think you're pretty much dead.
We are right at 6 o'clock, which is our witching hour. So a couple quick questions for the panels. For Steve and Sherry, can the communicable disease exclusion survive jurisdictions like California and Washington that don't allow anti-concurrent causation language?
I don't think it's an anti-concurrent causation clause.
I was going to say, I think it will remain to be seen. I will tell you this, the event cancellation policies that I'm seeing have unique language that is very different than the policy language we see in other space. I have a feeling that these types of cases are going to be not only very fact specific, but they are truly going to be very language driven. And I know we say that in every insurance case that we have, but I do think that in this case, the event cancellation policies are going to be a creature and product of their own.
Question generally for the different panelists. How important has anti-concurrent causation language been with respect to the success of the virus exclusion, particularly the ISO form? I mean, the cases.
I don't think I've seen any opinion where that's been the reason for the result. And there's only a few states where anti-concurrent causation clauses are not enforceable.
I've seen a handful of cases where there was no ACC at all and it survived. I haven't seen any where it was rejected because there was no ACC. Typically, the anti-concurrent language is sort of cited as a bootstrap argument that, oh, by the way, anyway, whether there's another cause or not, there's this language.
I have a feeling that there's a lot more to be seen on it. I think that in terms of the briefing on some of that, we're going to need to wait and see what develops after argument and some of the appeals.
Finally, we had a question from Ken Abraham about strategy, and in particular, why are some insurers moving to dismiss and others aren't? That's kind of a loaded question for those of us on the insurer side.
Would you like me to answer that for you?
Go ahead, Sherry.
My best guess is that there might actually be some coordination among insurers looking at what's the low-hanging fruit and hoping to make inroads in other cases. And so I expect that, you can tell me I'm wrong, but I suspect that that might be the case.
Yeah,
Sherry,
I mean, when you get O'Melveny and Myers or Winston and Strawn, came to be on the other side of a coverage case involving a barbershop, you know that there's a plan.
There may
Well,
be.
I think also, I'm sorry.
I was just going to say, look, that doesn't happen. It just doesn't happen. They don't have any conspiracy theory type plans on this. I know that's not what Sherry was saying, but they don't get together. There are antitrust laws that actually might be impacted, but carriers just don't do that. Law firms, if O'Melveny and Myers, who I know represents a bunch of carriers, their attorneys trade briefs, things like that. But as far as any concerted plan, I don't think that happens.
I will
Yeah,
say.
I think Oh, sorry.
I think if you look at the sequence, part of what happened was that it started accidentally with that case in Michigan, and then we started getting a couple U.S. District Court rulings. And by Labor Day, there was a certain sense of inevitability that the train was leaving the station. And once the opinions really started coming in, it broke the logjam. I think early on, there was some reluctance on the part of some insurers, and others were more eager to move. Lloyd's, for instance, early on was much more aggressive. But once you started getting 5 opinions a day, there was no reason not to.
And I would add that a lot of it might just depend on whether or not you're dealing with an ISO form or a manuscript form. I mean, ISO forms, it's a lot of, or a virus exclusion, as opposed to a manuscript form that might make a motion to dismiss more complicated. Could be as simple as that.
And I would just say one thing as well. We were talking actually before we went live, I believe, about the whole trajectory of the case law that's developed in the context of COVID business interruption claims, and how remarkable it is that in a year's time we have 1,800 filings and 300 trial court decisions and 100 cases on appeal. That's really dramatic. And another thing that's dramatic about it is how many motions to dismiss not only have been filed, but have been granted. I mean, I've been at this for a long time, and it is not common practice in substantial coverage disputes to file motions to dismiss and expect to walk away from a case, because courts are hesitant to grant motions to dismiss in many, many cases, even when insurers would say the policy language is clear. And so I think we are operating in a little bit of an unusual environment overall in how cases are developing and what the trajectory of this litigation has been.
I also think, to your point though, Laura, that we've also seen a change and a refinement in the pleadings. I think some of the early pleadings that we saw were filed by people who were not practicing full-time in our space and were perhaps less robust than what we're saying. I don't know that they need to be as robust as we're currently saying, but I do think that it makes a difference when the pleading has been careful to hit all of the elements and be sure that it pleads physical loss or damage in a way that a court can find it, where it refers to some of the science and the like.
Yeah, I think we'll see some new additional case law develop in relation to those new pleadings, but there have certainly been evolutions in the filings on both sides.
Which is surprising, since we know there's been no coordination on the policyholder side, none at all. I think it's fair to say that there are a lot of unusual things about this litigation, and it's as if 20 years of environmental coverage litigation was compressed into a 14-month period. I don't think any of us have ever in our lifetime seen anything like this, and let's hope we never see it again. It is a little past 6, and I know people have places to go and things to do. I want to thank the panelists and Professor Baker and UPenn Law School for hosting this virtually. We hope that these insights have been useful to you. There's a lot to talk about. This is a space that's moving very fast, but it's important, and there are a lot of important issues to be resolved yet. So good evening, everybody. Stay safe, and for goodness sakes, go get vaccinated. It was a pleasure. We'll see you all later.
Thank you, everyone. Thanks, Mike.
Thanks. Bye, everyone.
Bye.